Thank you. Question from the jury. I think it's safe to say it's a two-parter. In order to find her guilty of criminal damage to property, we do not need to confirm her intent was to injure him, correct? We do need to agree her intent was to shoot the door and that a natural consequence of shooting the door caused his death, correct? My initial reaction is the first question is easier than the second question.
That's what Anna just said. You should reread the charge.
I think the answer to the first question is yes. I think the answer to the second question and the proper thing to do is to recharge on criminal damage to property in the first degree.
As well as causation in felony cases, Judge. Felony murder.
Well, they didn't ask a question about the felony murder.
Well, to me, the second part of the question is kind of combining felony murder. Because it says the natural consequence of the shooting of the door is what caused his death, which to me is going to the felony murder.
Let's go one at a time. Any proposal on the first part of the question?
Yes.
Just simple yes?
Yeah, we do not need to so the question was, we do not need to confirm her intent was to injure him, correct? And I think we could just put yes or correct.
Defense?
With respect to the first question?
With respect to, we do not need to confirm her intent was to injure him, correct? Question mark. Underline, not underline intent.
Correct.
Are you ready? So what I propose is we label it 1, and Mr. Preston, if you don't mind retyping the question, including the underlines, and then the response is correct. All right, catch up on that.
Yeah, that's what it leaves out. It's almost 2 parts. It's almost 2 parts. But as the cause of death is talking about causation. And they're kind of conflating the two. Natural consequence. It's not a natural consequence. second answer is probably agreed. The intent is knowingly, without authority, endangering property in there. All three. That's the intent. That's three.
You good with that?
Yeah.
State's proposal on, we do, underline do, need to agree her intent was to shoot the door and that a natural consequence of shooting the door, parentheses, or brackets, caused his death, close parentheses, correct, question mark.
Judge, we would propose that Your Honor bring them out and recharge them on criminal damage, felony murder, and the causation. Right.
Hold on a second.
Yeah, just the felony murder obviously adds to criminal damage.
Two 26820, criminal damage to property in the first degree. I'm sorry, what else?
The felony murder charge as to criminal damage.
Page 8, is that correct?
Yes, let me triple check.
On page 8?
Yes, Your Honor.
21020,
Then it's just a question.
Right.
Where's the causation?
what else?
I was trying to find it in the packet. Give me 1 second, Your Honor. The causation in felony murder 21030 on page 9.
Any other proposal?
That's it, Your Honor.
I have state's proposal 21020, felony murder, 21030, causation in felony murder. Page 11, 26820, criminal damage to property in the first degree. Defense.
Yes, sir. So this was part of our requested charges, was to tell the jury specifically that knowingly applies to each of the elements that follow it. So I think at this time, it'd be proper to give them that correct statement of law, that knowingly, that her intent must be to knowingly, without authority, knowingly interfere with property, and knowingly in a manner so as to endanger human life. Because they've asked very specifically for that, and it is correct. And to leave that out when they've asked the very specific question about intent and which of the elements it applies to would be a mistake. So our position is, and I think frankly, respectfully, I don't think the court has a whole lot of leeway with what they've asked for. They're asking for the intent. Does the knowingly, what does knowingly apply to? And it applies to all the elements, which would be knowingly without authority, knowingly interfere with property, and knowingly in a manner that endangers human life.
I'm not saying I'm necessarily going to give it or not give it. What was your request to charge number on that?
Give us just 1 second, Judge.
$46 maybe?
Yes.
Yes.
Thank you.
Drop the last paragraph. Yeah.
This is their request. And now they want to read. Yeah.
They're charged on that. That's already being recharged.
Yeah, we object to the reading of this charge, Judge. This charge has already been denied. There's a lot of stuff in here that they're not even asking about as far as the without authority and who has legal right and privilege to the door and like all these things. This just goes way beyond even what their question is. I think it's perfectly proper for Your Honor to reread the instruction that's already been given to them. And not to now add a new charge they haven't heard yet that also includes information that they're not asking about.
I think if you leave out the last paragraphs, Judge. Sorry, what? If you leave out the last two paragraphs of defendant's request 46. And you could even put knowingly without authority, knowingly interfered with property, and knowingly in a manner that endangers human life. In other words, it would just be set out. Instead of in one, you'd put knowingly without authority, knowingly interfered with any property, knowingly in a manner that endangers human life. And that would get exactly the same thing. And you could even cut out the paragraph below that.
They're asking.
They're asking about the intent, and that is the intent that's required. So I would say you can cut out everything below 4. You just put knowingly without authority, knowingly interfere with property, and knowingly in a manner that endangers human life. The defendant acted, I guess would be the word after the.
Yeah, I hear what
Okay.
you're saying. I don't think that.
May I approach, Judge? I just marked it up.
Can you show it to them?
Yes.
Thank you. State?
Judge, I don't think that we should be charging them on anything other than we've already charged them on, and reread the charge as pattern that we've already read for criminal damage, felony murder, and causation of felony murder. I think it would be improper to start adding things to a charge. Your Honor's already declined defense's request to charge, and I don't think that it's proper to now change the charge that they already have. I believe that what we've charged them on is pattern, it's the appropriate law, and that would be the appropriate response to their question.
And the appropriate response to the question is the correct statement of law on the exact issue that they've requested.
Which is the pattern, right?
No, they've asked specifically about the intent. Does it apply, and what does it apply to? And it's correct to tell them that. And to leave it out, and they don't know knowingly applies to the conscious disregard. And that's the gravamen of the offense.
Yeah, there's no conscious disregard in.
Well, to the whatever, to the last element. And knowingly endangering human life.
Yeah, I mean, the correct statement of the law is the statute. That we shouldn't be adding words to the statute. The statute is the correct statement of the law. The statute is what the pattern charges and what we've already charged them on. It's not an incorrect statement of the law to charge them on the statute.
They've asked.
Well,
Again-
hold on. I'm certainly going to charge them on page 11, 26820. I mean, that's going to happen. So, I mean, that's,
So
so hold on. So the only question is, with their specific question, do we go a little bit further? And here's where, I mean, on the first one, it's correct. On the second one, it's, we're not going to tell you whether it's correct or incorrect. We're just going to read you again, which is, may very likely be what happens, and that's fine.
And so how?
I mean, they're partially right, partially wrong. I mean, yeah, kinda. I mean,
How about we charge them also on intent? If their question is about intent, there's literally a pattern jury charge on intent, 14110. We charge them on the pattern jury charge of intent so that they know that criminal intent does not mean an intent to violate the law, but means simply the intent to commit the act. It also talks about how intent is an essential element of any crime. It must be proved by the state beyond a reasonable doubt. Like it covers all of that as far as intent. And then charging them on the statutes for the two crimes that they're asking for. That is all correct statement of the law, and it's a direct to their question.
They're only asking about intent as to one charge. They only have a question about that, and they specifically put in their question, we do need to agree her intent was to shoot the door, and then they make a mistake, and they say a natural consequence of shooting the door. That's incorrect. And then they put in parentheses, endangered human life. Her intent has to be to knowingly endanger human life. That's the correct answer. That's why we have to tell them that. We don't just go, well, intent generally is this. They're asking about this charge. The intent is knowingly endanger human life, period, in
Yeah.
the story.
Yeah.
go ahead.
I think that's a complete misstatement of the law.
Which part? The knowingly part?
The knowingly endangering human life. She has to knowingly commit an act, which in turn endangers a human life. She has to knowingly commit the act, which is shooting at the door, and that act.
Hold on, let me run this by Alan. I'm not saying I'm going to give it. For the charge of criminal damage to property in the first degree, the state must prove beyond a reasonable doubt that the defendant knowingly interfered with the door without authority in a manner that endangered human life. Knowingly means she was aware of her conduct. It does not require proof that she specifically intended to damage the door for its own sake or she intended to injure the victim.
I think that's,
I don't think that's correct.
yeah. I
Okay,
think
that's fine.
I think the knowingly is.
See, here's where we get into it because it's not quite correct. And if we're just going to read what they already have. I mean, they have a copy of this back with them.
The shortest answer.
Without, answering their question.
And they've asked specifically just about the intent about criminal damage, and specifically with respect to endangering human life. The correct answer, the answer that is clearly the correct one, is they have to prove that she knowingly endangered human life.
That is
That's the answer.
incorrect.
That is correct.
That is incorrect.
One at a
The
time.
rule,
Go ahead.
the rule started in the United States Supreme Court with the Flores-Figueroa case, which was extended into our Scott case that we put into our brief. When the word knowingly is put in a statute, it applies to every subsequent element of the offense. That was the trafficking statute that struck down the trafficking statute about whether knowingly applied to the weight. And our Georgia Supreme Court, following the U.S. Supreme Court, said, when you see knowingly at the beginning of a statute, it applies to all the subsequent elements. And they're asking specifically, they're saying, hey, what is the intent? Is it just that it's a natural consequence, but then they put parenthesis, endangered human life? They're asking, does knowingly mean knowingly endangered human life? Because that is the element that has to be proven by the state beyond a reasonable doubt. It's the correct answer to tell them, knowingly endanger human life. There is no argument to the contrary that's correct. This is the law. Knowingly endanger human life, period.
All right, state.
Judge, that's incorrect. The element is interfered with any property in a manner that endangers human life. He's separating elements. You don't have to knowingly endanger human life. The intent is committing the act. The intent in this crime is you have to intend to commit the act. That act endangered human life. It is that he knowingly and without, it's that she knowingly and without authority interfered with property in a manner that endangered human life. She has to knowingly interfere with that property, and in doing that act, endangered human life. He is incorrectly stating the law. My computer's not working, I'm trying to pull it up. But the knowingly does not apply to in a manner so as to endanger human life. That is an incorrect statement of the law. That is why that would be incorrect to add that into the pattern. He's separating one element into two and adding knowingly where there shouldn't be one. There is an intent to knowingly commit the crime. She has to knowingly commit the crime, not knowingly endanger the human life. He is misstating the law. That's why I propose reading the statute and the pattern as charged, because that is a correct statement of the law, instead of adding the word knowingly in front of lines where it doesn't apply.
And the reason it's knowingly, in addition to the fact that that is the law, is because she has to knowingly be endangering human life. That's the scienter. This is the gravamen of the offense. Knowingly endangering human life. She can't unknowingly endanger human life and be guilty of criminal damage first. That's not the crime. The crime is knowingly endangering human life. Doesn't mean she has to intend to take a life, but she has to knowingly be endangering it. It is a criminal negligence offense, in essence, knowingly endangering human life. They've asked specifically, and they're conflating natural consequence of the act with what the actual element is, which is knowingly endangering human life.
Okay. Give me a second, please. All right, well, is your computer up to speed?
What I've been, it's freezing off and on. The case law I found, Judge, basically says that, like the one that I was trying to read right now before it froze, was saying that the knowingly as part of endangering human life for the criminal damage means reckless endangerment rather than actual endangerment. So like you can commit criminal damage to property when no one's even in the building and you shoot into an uninhabited building. And so it's more so you're knowingly committing an act that could endanger human life. I've also seen examples of arson where arson also includes the language knowingly, and it had the same exact, basically it's more of a reckless than it is an intent to injure or an intent to endanger human life.
All right, so let me interrupt, and we'll talk about this a little bit further. Is there a point in bringing them back and me rereading what they already have back there? Or do we say, look at page 6, page 8, page 9, page 11?
I mean, that's fine. I think it gets the same effect across.
I think there is. I think we have to answer the second question with a correct answer. I think the correct way to deal with it, respectfully, may I remain seated?
Yes.
Would be to answer your first question. We do not need to confirm her.
So the answer to the first question, we do not,
Yeah.
the response is correct. And so
Yes.
I've already written up, and I intend to send it back to them, is we will address question 2 in court, which we can do, or I can change it and say,
I think-
read these 4 charges in this order.
I don't.
And I understand you disagree with that.
Yes, sir. I think that we have to answer both the questions for them correctly. And I think the answer to the first question is yes, but to then not include the answer to the second question is highly confusing to them. The answer to the second question is, we do not need to agree her intent was to we do need to agree her intent was to shoot the door. They're just talking about the act. And that a natural consequence of shooting the door caused his death. Not correct. Not correct. We do need to agree that her intent was to knowingly interfere with the door and knowingly do so in a manner that endangers human life. That's the correct answer to the exact question that they've given. And I don't think that we should split it up, the answers, because they're asking all around the criminal damage intent. The correct way to do it would be, the answer first one is yes. The answer to the second question is, we do need to agree her intent was to shoot the door and that she did so knowingly, without authority, and knowingly in a manner that endangers human life.
And Judge, many times the correct answer is just to read them the appropriate charge.
I agree that in a large percentage, I do have concerns that they've narrowed in on a very narrow issue. So I mean, my initial inclination is just to either reread or point out charges to them and see if they have any follow-up on it. That's my initial reaction. However, I do find somewhat compelling defensive argument to try to be as specific as possible with the correct statement of law. And I understand that the parties disagree on what the correct statement of law is or is not. State, do you need more time on anything?
No, Judge, just that I'm just continuing to read cases that all say the same thing as far as the endangerment of human life, that the courts consider it more of a reckless endangerment than anything else, because you can commit the offense of criminal damage in the first degree by shooting into an uninhabited building. And so, again, it's just you're knowingly committing an act that whether or not it actually does endanger human life, it's basically reckless to do so because it could endanger human life, is what all these cases are saying, which is why the state's argument is that to put in there that you have to knowingly endanger human life is an incorrect statement of the law, because you don't necessarily have to actually endanger human life. You just have to knowingly commit an act that is basically reckless endangerment because your act could carry with it the possibility of endangering human life. That's why state's position is that Mr. Willis's statement of the law is incorrect. And I was looking specifically at 272 Georgia 378, which is a Georgia Supreme Court case, Carthern v. State.
That's frozen again. I have one.
Oh, okay.
It's working fine. You can take it.
Defense, you had something?
Just going to restate that I think we tell them, answer your first question, and then state the question is yes. Answer to the second question, we do need to agree her intent was to shoot the door and that a natural consequence of shooting the door causes death, correct? That is not correct. You need to agree that her intent was to shoot the door and that she did so knowingly and without authority and knowingly in a manner that endangered human life.
That's the point. That's aggravated assault. I mean, it's just an incorrect statement of the law. Every single case I've read on criminal damage to property over and over says it's a reckless endangerment, not an intentional endangerment. You don't have to knowingly endanger human life. You knowingly commit an act that could endanger human life, and so your act is essentially reckless. You can shoot into an empty building,
So
not a single
let me
person's in
interrupt.
there.
So what we're going to do is I'm going to direct them to reread certain parts. I'm not going to invite a question. If they have a question, essentially, Judge, that's not what we asked you, then we'll see where we go from there. So defendant's specific request is denied. Any preference of order, or just say, look on these pages with this number?
Just chronological order of pages is fine, I think, makes the most sense.
We're saying yes.
Yeah, he's saying correct
Yes.
for the first one, and then the pages for the second one.
So it will be something along the lines of this. Question 2, please look on page 6, 1.41.11, no presumption of criminal intent. Return. Same verbiage. Please look on page 8, 2.1020, felony murder. Same verbiage. Please look on page 9, 21030, causation in felony murder. Same verbiage. Look on page 11, 26820, criminal damage to property in the first degree. That's our first step over defendant's objection. I'll take inquiry on that. I'll allow defense to preserve their record if they need to.
I'll do so after the charge of the court. Thank you.
I think they're just turning it up. No.
For scheduling purposes, I will go as long as the jury wants to go today.
Yes, Your Honor.
For, and I'm not blaming anyone, but for sheriff department, et cetera, we will not have court on Saturday. So if this goes past today, it will be on Monday.
Yes, Your Honor.
print out a bunch of them for them.
These are. Yeah. Thank you. No objection, Judge.
Same objection.
Same objection is noted for the defense. This question will be labeled C7, Court 7, and will be given to the court reporter in a moment. I will send a copy back of their question so they know what it was, just in case they might have forgotten. I'm going to do basically a duplicate original of C8, which is signed and dated by me. Madam Court Reporter, C7, C8, please. Thank you. Anything else from the state?
No, Your Honor.
Anything else from the defense?
No, sir.
Chief Bailiff, I'm going to hand you a copy of their question. And then I'm going to hand you a copy of the court's response. Thank you.
And at this time, since we're sending the response back, I guess I'll just restate our objection officially to the charge in response to the juror's note. We're renewing our previous. I'm sorry? Yes, okay, but have just a second.
Yes.
We're just renewing our objection and requesting states.
You can go ahead and take that back. Thank you. Go ahead.
We're renewing our objection to the states, to the court's response to the jury's note, and asking for a ruling on our objection to the court's response to our objection.
Meaning your proposal.
Yes,
Okay, to be clear, that proposal is denied for legal purposes.
thank you.
All right. Anything else?
No, sir.
No, Your Honor.
Okay. No comment one way or the other. Don't go super far just in case they review it and go write another note. But I'm going to step off the bench and they may not respond or they may respond immediately. All right?
Your Honor.
Thank you.
He'll leave you say hi, Matt. Nice to see you again. Yeah, it's on something.
All right, some administrative things. I believe we're on court 8, 9. Sorry about that. Court 9 is the note I gave to our alternate excusing her. Y'all were copied by email. Give that, Madam Court Order. C9. C10 is the 2-page question. C11, well, I won't number that yet. Well, yeah, I will. C11 is the question number 2. Y'all have been provided a copy by my staff attorney. Hear from the state first and then the defense.
Judge, as to question number 1, I believe that the correct response to this would basically just be yes. Isn't it true we should consider Mr. Barron's likelihood of reasonable apprehension of fear of immediately receiving violent injury from the perspective of a reasonable person in the known context? It's a reasonable person standard, so I think the answer to that would just be yes. And as to the second question, I think the obvious answer is yes.
All right, so question 1, is there any additional information you can provide beyond what is already in the jury instructions related to aggravated assault, specifically regarding ... or committed an act that placed the person in reasonable apprehension, it says, or fear, apprehension or fear immediately receiving a violent injury, close quote, question mark. Page 2 of question 1, isn't it true we should consider James Barron's likelihood of reasonable apprehension, quote, of reasonable apprehension or fear of immediately receiving a violent injury, quote, from the perspective of a reasonable person in the known context? So that's Court 10, page 1 and page 2. We'll go to C11 in a moment. Defense.
Talk about C10.
I'm talking about C10, which on your copy, it says question 1, and then there's a smaller to the top right that says 1 circled, which it leads me to believe that is page 1, and then 2 circled, which leads me to believe that's page 2. And so then there's a question 2. So on page 1 and 2, which is question 1, what say the defense?
The answer to the first question is the state must prove beyond a reasonable doubt the defendant's act of, quote, firing a weapon through a door, which is the allegata in count 4, placed James David Barron in reasonable apprehension of immediately receiving a violent injury. That's the correct answer. The state must prove beyond a reasonable doubt the defendant's act of firing a weapon through a door placed James David Barron in reasonable apprehension of immediately receiving a violent injury. That's the answer to 1. The answer to 2 is, on page 2, is no. Their question, whether or not they should consider James Barron's likelihood of reasonable apprehension or fear of immediately receiving a violent injury from the perspective of a reasonable person in the known context, that answer is no. The question is, you should consider whether the state has proven beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed him in reasonable apprehension of immediately receiving a violent injury. That's the correct answer to 2. They're confused, Judge, respectfully, and I suspected that they would be. They're confused about whether or not they can just say, was he in reasonable apprehension, and not connect it to the charged allegata, which is by firing the weapon through the door. And so the response should be, state has to prove beyond a reasonable doubt that the act of firing through a weapon through a door placed him in reasonable apprehension of immediately receiving a violent injury. That connects it up. And then the answer to 2 is no, it's not they don't just assume. They're asking, do we just assume whether a normal person would? That's not correct. The question is whether it's been proven to them beyond a reasonable doubt that he did. So the answer is no. They should consider whether it's been proven beyond a reasonable doubt that the act of firing a weapon through a door placed him in reasonable apprehension.
Response? State. You can come on.
Well, I was just trying to find the, couldn't figure out what page it was on, the charge on aggravated assault.
I believe it's page 11.
Oh, thank you, Judge.
It's 240-30.
So Mr. Willis's first statement as to the first page about the state has to prove, and then basically just implanting the language from the indictment in the statute is a correct statement of the law. I don't see any problem with doing that. I think the only thing that Mr. Willis and I differ on is the response to page 2, because I just think we differ on the answer to the page 2.
What's your proposal?
My proposal was to just answer yes. I don't think there's any problem with restating the statute, including the language from the indictment, because again, that's a correct statement of the law. But as far as, isn't it true, we should consider the likelihood of reasonable apprehension of fear of immediately receiving violent injury from the perspective of a reasonable person in the known context. I think that's where we differ. I'm reading the way that we charged them. I think I would prefer, if we're not going to respond yes or no, I think that I would prefer, as to page 2 of question 1, that we reply with, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving violent injury, and leave it at that. Because that's a correct statement of the law. The state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. That's directly from the charge of aggravated assault, the pattern. And so I think the state would just request that we put just that one sentence from the charge in the response. I think that directly answers their question. It's a correct statement of the law, and so that would be the state's request.
I think you should say no as a response to 2, and then I don't have an objection to reading that part.
All right, so let's, if you would, and I'm not saying I'm necessarily going to give these, your response to the second part, page 2, if you would type that out and send it to Mr. Preston, we'll print it out. Defense, your response on page 1, same, and then we'll compare notes, please. And then we'll focus on that before we move to question 2, please.
Which is what I did.
Defense need a printed out copy, or you find on digital
Of the,
what the state just emailed.
I emailed it to you.
I have it.
Okay.
Are you okay with a digital copy?
with what they just sent?
Would you like a printed out copy?
No, sir.
Okay.
But we're not consenting to that. We want the word no in front of it. Okay.
I understand that. State, are you okay with the digital copy, or do you want to
Yeah,
print?
I'm good. I'm good with that, Judge. I appreciate it. Thank you.
All right, focusing our attention on Mr. Willis's proposed answer. The state must prove beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed James Barron in reasonable apprehension of immediately receiving a violent injury.
No, I have no objection with that, Judge.
That will be the answer to the first page, question 1. The defense is okay with this, but wants the qualifier of no in the beginning, if I understand. State's proposal, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury.
The reason we want the no, Judge, is because it's a specific question. Isn't it true? First question doesn't have that, just they want more information. So isn't it true? The answer is no.
State, I think the defense makes a fair point. I'm hearing from you.
The reason why I'm hesitant to put no is because I'm doing some research on the validity of the no, and I think sticking with the pattern charge is a correct statement of the law, and
I'll give you a few moments to continue
Judge.
research. I'll hear from the state. The jury asks a specific question, and the answer is no. I'm inclined to put no period and then put in the response that the state proposes, essentially no period return, and then what you've provided by email.
I'm sorry, so putting no and then what I typed out essentially?
Whoever did it, Ms. Ali's email.
Yeah, I'm using her computer, sorry.
Yeah, that's fine.
Okay.
That's not a final ruling, but that's where I'm going.
Right, so the answer will be no. You're saying from any reasonable person's perspective.
And Judge, I'll just note, my counsel has reminded me, we had asked the court not to charge
Yeah,
on
they
both
are.
species of assault, and we're not waiving that previous objection to the charge. This is a previous objection we had, so we just want to note that we're not waiving that. We still don't think that we should have charged on both species of assault, the intent to injure and the reasonable apprehension. And after the court sends it back,
Noted.
yeah.
I think, so they're asking from his perspective. They're saying, so essentially, obviously, the right answer is, from his perspective, was he placed in reasonable apprehension of receiving immediate violent injury?
The person.
Correct, which would, in this case, would be Mr. Barron. So maybe just to make it, instead of putting a yes or no, instead of putting the person, we put in James Barron. So it reads, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed James Barron in reasonable apprehension of or fear of immediately receiving a violent injury. That way it's clear it's from his perspective. So it's beyond a reasonable doubt. So it's reading that committed an act that placed James Barron in reasonable apprehension or fear of immediately receiving a violent injury.
Which is what I proposed initially.
Well, if you proposed initially, then you assume you're good with it now.
I'm good with it now. As long as I have a no at the beginning.
Well, that's what they don't want, so
What? I'm sorry.
he wants the no at the beginning.
Yeah, I would just rather not say yes or no and just restate the law, but including his name so that it's clear that it's not just any person, it's James Barron in reasonable apprehension or fear of receiving injury. Just because their question is kind of confusing, so answering with a yes or no is what concerns me, which is why I believe restating the law, but including his name to make it clear that it's not just placing any person in reasonable apprehension, but it's that the act placed James Barron in reasonable apprehension or fear of immediately receiving a violent injury.
Defense can take a moment.
sending the court my proposed response. It still has a no at the beginning.
Am I copied in it? Or
Yep,
can
you are.
Can you copy now?
I just sent it,
That's okay,
sorry.
I have my phone.
Let me forward it to her. Previously, they asked a specific question, and we gave them a yes or no, so I think we should tell them no. If it doesn't tell them no, then they think they're on the right track, and they're not, so.
I have no problem with what Mr. Willis has just sent. The state must prove beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed James Barron in reasonable apprehension of immediately receiving. In reasonable apprehension, he did leave out the or fear. Reasonable apprehension or fear of immediately receiving a violent injury. I have no problem with that. Except for adding the or fear.
But it's not from the perspective of a reasonable person.
I know.
That's what
I'm saying-
hasn't been corrected, is what I'm saying. If we don't tell them no, then they can think, well, yeah, but did he do it? But now I'm just going to guess and see whether a reasonable person would. The answer is no, so we should tell them no respectfully.
Right. Include the facts.
What's the state's concern about telling them, no, it's not a reasonable person?
Because I find the question to be confusing based off of how they're viewing it. And I don't think that there's any error in simply restating the law to them, but including the facts of this case to make it clear. Like Mr. Willis's proposal of you should consider whether the state has proved beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed James Barron in reasonable apprehension, and then adding or fear of immediately receiving a violent injury is an absolute correct statement of the law. It instead of just rereading the charge to them, it includes both the indictment language as well as the victim's name. And so I think that helps answer the question without potentially incorrectly answering what they might be trying to figure out, because I find their question to be confusing. And so I would prefer to just insert the facts of this case to the law and read that to them. It answers the question without a yes or no. It gives them the correct the correct law without giving a yes or a no.
Last word, defense.
They've asked, isn't it true? The answer is no. We should tell them no and then tell them what the correct answer is.
Because, I mean, the reason why I think it's confusing, Judge, is because it's
Last
not like
word.
We'll go another round.
It's not like anybody could ask Mr. Barron, were you in fear? Because he's dead. And so even though it is obviously that the state has to prove whether or not he was in reasonable apprehension or fear of receiving injury because he's dead and nobody can ask him, it's really up to how they're viewing the evidence in this case as far as whether or not he was placed in reasonable apprehension or fear. And so that's why I think that this question is confusing based off of what we know about the law. And so I would prefer to just give them the correct law. There's nothing improper about giving them correct law and then including the facts of this case. It's answering the question without improperly assuming what they're asking is, I guess, the reason why I'm hesitant about giving a no.
All right, so not to quibble, but it says, isn't it true we should consider James Barron's likelihood of, quote, and they're tracking, reasonable apprehension or fear of immediately receiving a violent injury, close quote. That's the setup. And the question is, from the perspective of a reasonable person in the known context.
And that's why I don't think it's necessarily no, because again, nobody can ask Mr. Barron in that context if he was scared because he's dead. And so I don't know exactly what they mean by that, because typically if you have a live victim in an aggravated assault, you would elicit testimony about how did that make you feel? Were you scared? That's how you're able to prove this element. When you have a dead victim, you can't do that. And so you really are kind of judging the evidence based off of, if a person like Mr. Barron were in his shoes based off the evidence, was he in fear? That's why I think this question is confusing, because I don't know how they're thinking about it. And so to answer no, I think would be improper, because that implies that basically the state had to, we can't ask him if he was in fear. So they're going to have to kind of put their own imagination in the head of Mr. Barron in that context to say, was he in fear in that moment, which might be to them a reasonable person in that context.
All right, last word. Defense.
Yeah, the answer to their question is no, because it is no. It's not from the perspective of a reasonable person in the known context. That's just false. And to not answer that is a mistake. So I think the answer is no. And one last thing, Judge. Ms. Bennett had said I didn't put the word "or" fear in my charge. And I just noted this error. In the statute, it actually doesn't say the word fear. It just says reasonable apprehension of receiving a violent injury. So the word "or" fear doesn't belong in the charge. I don't think we need to do anything about it now, but we don't want to remake that error by putting the word "or" fear, because it's not in the code.
I think that's pattern. This is straight from the pattern,
It is not in the code for assault.
straight from the pattern jury charge.
Assault says commits an act which places another in reasonable apprehension of immediately receiving a violent injury. It's in 16.520A2. So "or" fear is not part of the code, so it shouldn't be in the recharge.
Okay.
I have it in my attorney folder. Oh my God. No, it's okay. Yeah. It's in the pattern. What's right? Take it. What is the? That's the update. That's the most recent. Thank you. This isn't an that's my computer. I don't know whose computer I have.
It doesn't matter, I don't care. One of them's fine.
Anything else from the state?
No, Your Honor. I just double checked that fear is in the pattern charge, so it wasn't an error.
All right, the final answer is on this is that I am going to put the no because it is responsive to their question. I hate to get into minor semantics, potentially no comma and then lead into, which is, I think maybe the better way to do it.
That's fine.
Okay. And then I'm going to go with Mr. Willis's 531 email language, but adding the two words "or fear" after the word apprehension.
Yes, Your Honor. Thank you.
So no comma, you should consider whether this, I apologize. You should consider whether the state has proved beyond a reasonable doubt that the defendant's act of firing a weapon through a door placed James Barron in reasonable apprehension or fear of immediately receiving a violent injury, period.
Yes, Your Honor.
That's C, hold on, that's C10, page 1 and 2, over defendant's over state's objection of the no. Sorry. Are you ready for question 2?
I think we are both in
Yes.
agreement, Judge, that the answer is yes.
Answer is yes. And will the court be sending, when you send back the answers, do you send back their sheet so that they can refer back to know what, you know what I'm saying? Because if they don't have their note because they've handed it to you, and they don't.
Yeah, so to answer your question, the packet you have is stapled with 3 pages.
Yes, sir.
I return that back.
Got it.
The original is with court reporter, so you're correct. They,
Okay.
just in case they've forgotten the question, they're provided with what their question was. And then collectively, I'm going to finalize the paper that will go back as C12.
Got it. Thank you.
Thank you.
Okay. Okay.
Giving the court reporter C11, which is question 2. Handing the court reporter what I believe is C12 is what we agreed, or what I stated, which is a copy of the response. Thank you. Handing the chief bailiff a signed copy of the response that y'all have, as well as photocopies of the 3 pages that they presented to the court. Defense, have you had a chance to review C12?
Yes, sir. And we have no objection to this proposed response. We will just restate our previous objection that ties back to the demurrer with respect to charging both species of assault for the record, and ask the court to rule again on that, just so we don't wait.
Noted and denied.
Thank you.
And then you object to the no comma, but other than that, we're moving on.
Yes, Your Honor.
Thank you. Anything else from the state?
No, Your Honor.
Anything from the defense?
No, sir. Well, let me ask this. As far as timing, would you prefer us to?
Just as anyone else who's in the courtroom, I can guess. I mean, I would guess that they're going to review that and either keep working for longer or
Yeah. Okay.
potentially reach a verdict, or potentially say, can we come back another day? So they're either going to let us know, I would think, within about 15 minutes or so, or they're going to do a deep dive.
Can we have a picture real quick?
Yes. That will be in recess. Thank you.